mine who lives in South Florida, way on down South Florida. And I kept hearing birds during our conversation. And at one point I asked her, I said, I'm hearing a lot of birds and chirping. And she said, oh, yeah, I'm just sitting in my backyard eating lunch, enjoying a beautiful sunny day. I just hung up on her. Well, I'll show you. Oh, let's see. Brandon Wood, Mr. Wood, when we get to Parker versus Vanderbilt, can you help us with it? Miss Brown, Hope Brown.
Is it Madison Jada Hope?
Say again?
Madison Jada Hope?
Yes. How about Tennessee Farmers versus American Mutual? Jeremy Clark. Mr. Clark. Jeremy. Nope. Olivia Lindsay. Miss Lindsay. Nope. How about Terrence Clayton? Yes, I'm sorry. You don't have to be here, you know. You get to be here. How about Craig versus Gentry, the popcorn popper case? Garrett Dodd. White versus Refco. I know I'm going to mess this one up. Tracy Aquazi. Oh. Okay. I mean, this is torts, right? Lisa Hill. The last one goes to you. Lisa M. versus Henry Mayo, Newhall Memorial Hospital. If we don't get to that one tonight, we will next week. Okay, so tonight we are going to begin considering the subject of vicarious liability, which sometimes goes by the name of imputed negligence. But by whatever label, imputed negligence, vicarious liability, it simply means that because of a legal relationship that exists between A and B, B is liable for the negligence of A, even though B played no part in it, had in no way encouraged it, and maybe even did everything possible to have prevented it. But because there is a certain legal relationship that exists between A and B, B is liable for the torts committed by A. He is vicariously liable. Or maybe to say the same thing a little bit differently, the negligence of A will be imputed to B because there is a certain legal relationship between the two. And so, what we're going to do tonight and also next week is explore these various legal relationships that will trigger vicarious legal responsibility. And the first one is a big one, it's one of the major ones. And that is the relationship that exists between an employer and an employee. The rule here, the starting point, is that an employer is vicariously liable for the torts committed by employees, provided that those torts are committed within the course and scope of the employment. So that's the basic common law rule. An employer is vicariously liable for the tortious acts of employees committed within the scope and course of the employment. Now, before delving into the details, I think it may be helpful to distinguish the employer's vicarious legal responsibility from an employer's direct legal responsibility. Let me try to explain that this way. An employer, just like any defendant, can be held liable when the employer is negligent in its own right. Maybe, for example, in this context, the employer failed to exercise due care in selecting an employee that turns out to be the bad actor, or maybe was negligent in supervising the employee, or training the employee, or retaining the employee. But in each instance, the employer is negligent and certainly can be held liable for that negligence. That's not vicarious legal responsibility. In each of those instances I've just described, the employer has done something, and I almost hesitate to use this word because it conjures up our discussion the last few weeks, but fault. The employer is at fault. The employer deviated from a standard of reasonableness. That's not vicarious legal responsibility. Vicarious legal responsibility involves an employer who is faultless, an employer who was not negligent, nonetheless being held liable for the negligence of an employee. So as we go through this vicarious liability issue involving employers and employees, bear in mind that if for some reason the vicarious liability principle doesn't apply, that doesn't mean the employer is necessarily off the hook. To the contrary, that defendant, that employer, is on the hook if the plaintiff can prove that the employer itself deviated from a standard of reasonableness. That is, they were negligent. Make sense?
Yeah.
In the context of employers, employees, and vicarious legal responsibility, there's a term, a Latin term, and you've seen it in some of these cases, and that is respondeat superior, which is Latin for anybody? Let the master answer. Or as we might say in this context, let the employer answer. Or as it's sometimes translated, look to the person higher up. Respondeat superior embodies this common law concept that employers are vicariously liable, even if they didn't do anything wrong, they're faultless, they're liable nonetheless because of this respondeat superior principle. That is, through the eyes of the law, the employee is viewed as an agent or an extension of the employer. This doctrine of respondeat superior doesn't apply if at the time of the negligent act, the employee was not acting within the course and scope of the employment. And so this necessarily requires that there be an employer-employee relationship in the first place. Consequently, in any respondeat superior type of case, the first question that has to be addressed is whether that would-be employee, that is, that the actual tortfeasor, is that person in fact an employee, as opposed to having some other status like an independent contractor. And that's the question that the court took up in Parker versus Vanderbilt, a case that we've looked at before, but in a much different context. So let's work our way through Parker versus Vanderbilt. Mr. Wood, tell us about this one. Floor is yours.
All right. Can you guys hear me?
Yes.
All right. On June 17th, 1984, Richard O. Parker was shot in the back with what was described as a small caliber handgun as he was trying to escape from an armed robber. He was taken to the Nashville General Hospital. Nashville General was furnished by Vanderbilt University under a contract with the Metro government. On June 17th, Dr. Powell, Kruger, Alexander, and Peacock were on duty in the OR. Sandra Connor, a nurse anesthetist, and Rebecca Murphy, a student nurse anesthetist, provided the anesthesia services in the OR. Dr. I headed the department, but was not there that night. When he was admitted, Parker could walk and had good vital signs, but after an exam in the ER, he was admitted for surgery. The operation started with the doctors putting a tube down his throat in order for him to breathe. It was not.
That's important.
Doctor.
No.
The nurses, sorry. Yeah. The student nurse.
Okay. So the student nurse anesthetist inserted the endotracheal tube, which is the tube that supplies oxygen when you're unconscious, but there was a problem.
The claim was that the tube entered into the esophagus and not his trachea, which shut off oxygen intake for 12 minutes.
Okay, so his stomach got plenty of air, but his lungs and hence brain got no air for a period of about 12 minutes. Try holding your breath for 12 minutes and see what happens. So, what happens?
So multiple complications came from the lack of oxygen flow. It was determined that he had severe brain damage. Mr.
What
Parker,
happened in the OR? I mean, the student nurse anesthetist puts the tube in the wrong pipe. What then happens to him, to the patient, who morphs into a plant?
besides him losing oxygen,
You need help? You got a bunch of smart embryonic mortars out here. Call on one of them.
anybody?
His heart rate.
Oh, heart rate, the heart rate, yeah, and blood pressure. Yeah. They had to cut into his chest and massage the heart.
Chaos erupts, right? The man begins to die. And you have everyone in the OR, all these surgeons trying to very quickly figure out why all of a sudden is this patient in major distress. I mean, his vital signs go crazy. They actually crack open his chest and begin to manually massage his heart. They're giving him all these medications. His stomach is becoming distended because it's filling up with air. They're trying to save the guy's life, and while all this is going on, the nurse anesthetist takes out that endotracheal tube and puts in another one, and she does it correctly, which restores oxygen to the patient. But as we said, 12 minutes goes by, and he suffers permanent brain damage. Who gets sued?
All of the doctors,
Everybody
Yep.
gets sued. The
And
hospital
the
gets
hospital,
sued,
yeah.
all the surgeons get sued, Vanderbilt gets sued, General gets sued, the nurses get sued, everybody gets sued. There's something like 12 defendants in this one medical malpractice case, we're talking. This appeal only involves a few of them. The first of which is Dr. Alcantara. Who is he? What is his role in all of this?
anybody. Alcantara. Head of the department. He is the head of the department.
Department of what?
Anesthesia services for general.
All right. So this defendant is the boss. He is the head of chief of anesthesia services in this hospital. This is the top guy that oversees all the anesthesia related moving parts of a hospital. And the plaintiff sued him. What did he do wrong in the OR? Or was he in the OR? And if he wasn't, How is it that the plaintiffs claim he's liable?
Vicarious liability.
So was he in the OR?
No.
Was he even on duty that night?
No.
No. Much less being there and having done something negligent himself. So no, he is not at fault. I know that's a loaded term at this point, but he didn't do anything to deviate from the standard of reasonableness. He wasn't even on duty. But the plaintiffs say, as you indicate, he's liable vicariously for the negligence of the nurses. He's the boss. Does respondeat superior apply as to him? Is he vicariously liable? There's no question that the misplacement of that tube was negligence. And probably it was negligent not to have discovered that for 12 minutes. So the plaintiff's argument is, you're the boss, you're vicariously liable for the negligence of these people, these nurses in particular, working under your ultimate supervision.
Mm-hmm.
Is he liable vicariously?
No.
No. Why not?
The court said that even being the chief of anesthesia services, he was not present at the time and had not had direct supervision over the nurses and thus could not have been held vicariously liable.
No, it's even more fundamental than that. This probably is the person who approved the hiring of those nurses, or probably at least approved the arrangement whereby the student nurse anesthetist could do her clinical in this hospital. And probably also, this is the person who wrote the protocols or had some hand in creating and implementing the protocols for delivering anesthesia in the OR. But as you say, he's still not liable vicariously. My question is, why? If he's the boss, why isn't he liable? Let me ask you this before I know, I see what you're about to do, but let's struggle through this just for a second.
Right.
In order for respondeat superior to work,
Mm-hmm.
what must be present?
No.
You know the answer. In order for respondeat superior to work, what must be present? There has to be what?
An employer-employee relationship?
Yes. Okay. Is there an employer-employee relationship here? He's the boss.
No.
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 Why no?
Because
He hired her.
they're lone servant.
No, we'll get to that in a minute. But you're right there. There has to be an employer-employee relationship, and here there is not. why is there not? Or let me ask it this way. Who did these nurses work for? Who, who was their employer? And for that matter, who was his employer?
Vanderbilt.
Huh?
No. General,
Vanderbilt.
Nashville General.
Yes. There you go. He was not the technical employer. There's no employee-employee relationship. He worked for the entity just like they did. So even though he might be the boss, if you want to think of it in those terms, or the supervisor, that doesn't somehow trigger respondeat superior / vicarious legal responsibility. Actually, they're coworkers. You want to think of it in those terms. Yes, he's a super, but there's no, absent the employer-employee relationship, there's no bridge by which to take the negligence of the nurses and impute that onto Dr. Alcantara. So, he's dismissed from the case, right? Well, the plaintiffs also sue the Vanderbilt surgeons, the residents. They're residents of Vanderbilt, but they're doing part of their training at Jennings. These are the 4 or 5 doctors who are in the OR trying to save the guy's life. How is it that the plaintiffs let me ask it this way. Let me back up one step. Assuming for sake of argument that the surgeons were not negligent, plaintiffs argue they're liable nonetheless. They're liable vicariously for the negligence of the nurses. How's the plaintiff get there? What's their theory? How is it that these surgeons, according to the plaintiffs, are liable even if they weren't negligent?
Allegations against me. Sure. Because they're claiming that they were employees.
You know?
Long servants.
One of the doctrines that the court talks about in this case is the captain of the ship doctrine.
Mm-hmm.
Captain of the ship doctrine. Again, one of those principles, you're not going to find that kind of thing in contracts or criminal law. I mean, it's in torts where you have the phantom tort visas. You have the captain of the ship doctrine and some of these labels that are quite descriptive of the underlying legal principle. So here the plaintiffs rely on this captain of the ship doctrine. How does that work in this context? What does that mean? What is the captain of the ship doctrine?
Essentially, what the court reasoned with the captain of the ship.
Now, make it real simple. The plaintiffs say the doctors are liable based on this captain of the ship doctrine because
When those persons are the servants of the,
go.
When
What's that mean, captain of the ship?
you're in charge.
How are these doctors the captains of the ship, according to the plaintiff? Just very simple.
I can't do that.
See what law school has done to your brain? I mean, I've said it many times in here. I mean, you just take on a disability of a legal education. When you're in law school. I love that. I can't even think simple things. I used to think simple thoughts, but now I can't do that anymore. My brain is turning to mush. But, well, somebody help him. Real simple. Yeah.
Those who take charges in the duty.
Okay. Yeah. These surgeons are in charge of the OR. That's the plaintiff's theory. You're in charge. You're the captain of the ship. You're in this room. You're the ranking person. So if something goes awry, you're legally responsible for it. You're the captain of the ship. Now tell us what the court had to say about this captain of the ship.
I have it written down that it was confusing and unnecessary,
Okay.
which I agree with. It's good enough.
Yeah, even the court can't think simple thoughts, I guess. Oh, this is confusing. It's really not confusing. Somebody, if you need help, just call on somebody.
Well, they gave us some elements.
Yeah, it's up to you. Where
Uh,
are we gonna take this?
Master is liable for torts if its servant is the tortfeasor is an employee, was acting within the scope of employment, and
Just
was
stop right there.
no. Okay.
Did these doctors employ the nurses? Were the nurses employees of these surgeons? No. Ipso facto, there is no bridge by which to take their negligence and impute that over on the shoulders of these surgeons. There's no employer-employee relationship. Absent that, there can be no vicarious legal responsibility. Remember, the first question that always has to be asked and answered in a respondeat superior type case is there even an employer-employee relationship? If the answer to that is no, that case is over. So Dr. Alcantara's out, surgeons are out. Now what about Vanderbilt? Plaintiffs say, Vanderbilt, these physicians are, they're your students, they're your residents. You have trained them. And so, assuming that they are negligent, assuming the doctors are negligent, plaintiffs say Vanderbilt University is vicariously liable. And you say that's wrong. They're not. How come?
Because
You actually mentioned this one.
they were loan servants of
That's
General
it.
Hospital.
So in this case, we not only have this captain of the ship doctrine, But we have this second doctrine that the court talks about, the lone servant doctrine. Okay, so what does that mean? And how does it apply to these circumstances? You're right when you say the court concludes that Vanderbilt University is not on the hook for the negligence of the surgeons, assuming for sake of discussion that they were negligent. And it is because of this lone servant principle. But flesh that out for us a little bit. What does that mean?
Be governed by written agreement,
Okay, what do you mean? What written agreement?
contract,
Between whom?
the employer and the contracted individual.
Yeah, between who? Who had an agreement?
General
Yes?
and the nurse,
No.
doctors, employees, people, defendant.
Huh? The contract was between General
General.
and say Vanderbilt.
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 Mhm.
And the gist of this agreement was that these surgeons would be receiving a part of their training under the supervision of General Hospital. And it was General Hospital that would assign them, that would set their schedule, that would supervise them. And so under this lone servant principle, these doctors effectively became employees of General. They were lone employees, lone servants from Vanderbilt to General. And that is why Vanderbilt University is not liable for the negligence of the physicians, assuming they were negligent. So that defendant is out of the case. When you put this one away, having looked at it now twice, what's the big takeaway for you? Legally.
I think it really depends on if an employee-employer relationship does in fact exist.
Yes, that's the whole point. When it comes to responding at superior, absent an employer-employee relationship, that case is over. You have to have that bridge in order to impute the negligence of A to B. Thank you, sir. I love how you did not give up. You didn't just throw up your hand. Well, I don't know. See, when you struggle through this, eventually you get there. So, well done. Anybody else have a different takeaway from Parker? It's okay. Anything? Yeah.
More so a question, and maybe I'll answer it myself, I'm sorry, ask it, but if it would have been, instead of against Vanderbilt, it would have been against the General, would that have changed anything, or it would have been the exact same situation?
My guess, and I don't know this, my guess is that probably General did get sued and settled.
Okay.
I thought you might be asking, well, what about the nurses? I'm sure they were sued and they settled.
Yeah.
So this opinion, the way the litigation shook out, you're only seeing a part of the litigation that was involved in the appeal. But you better believe that there are other layers to this that the court just, didn't mention because it wasn't necessary to resolve the issues on appeal. Yep.
You may or may not know this answer, but is this the start of when hospitals had kind of split to make their employees independent contractors, older doctors, or has this been the long document of that? I know they always say, you know, the surgeons are not employees of the hospital, so that you basically have to sue them for malpractice themselves and not the hospital. So they can
I really don't know whether Parker was sort of the genesis of that movement in terms of time. I don't know one way or the other. But I do know that within the last, 10 years, maybe 15, that has become pretty standard fare in the healthcare world. It's of course, there are always exceptions. Hospitals do it different ways, but a common thread is that the physicians are not employees of the hospital. The anesthesia people, like the CRNAs, like in Parker, very often they're not employees of the hospital. Often the nurses, especially ER nurses, in some cases I know ICU nurse. It's pretty common that when you get something done in a hospital setting, you are interacting in some form or another with people who are independent contractors and not employees. But just exactly when that started, I really don't know. But it's pretty common today. Okay, well, assuming that there is an employer-employee relationship, the next question is whether the employee was acting within the scope of the employment as opposed to what the cases call a frolic and detour. A frolic and detour. That simply means that the employee, the tortious actor, has stepped outside of the scope of his or her employment. And at that moment, they're engaged in a frolic and detour, which will vitiate respondeat superior. So not only must there be this employer-employee relationship, but at the time of the tortious act, the employee must not have been engaged in a frolic and detour. We've got a couple of cases that help flesh that concept out for us. The first of which is Tennessee Farmers versus American Mutual. And I believe, Ms. Brown, where are you? I think you've got this one.
Okay. Can you hear me?
Yeah.
Okay. So this case, the facts are Bobby Clay Thomas was a foreman for Macon Hardwood Lumber Company, a logging business owned by his father.
I'm sorry, I need to get my glasses.
Oh, you're fine. Owned by his father. He supervised approximately 10 employees and occasionally performed additional duties, including purchasing equipment and vehicles. In January 1988, Mr. Thomas was authorized to attend the Nashville Auto Auction and given full authority to purchase a pickup truck for Macon, and he informed his father that he would also look for a personal vehicle. Mr. Thomas traveled.
Okay, you're talking like real fast.
Okay, phew, sorry. I'll calm down. Okay.
So let's slow this down a little bit so that I can process with you.
Okay.
And so when you are in a courtroom and you're making an argument to a judge, if it's a trial judge, or 3 judges, if it's an appellate court, or 5, if it's the Supreme Court, and certainly if a jury is sitting there, you don't want them to have to struggle to keep up with you. And the tendency among all of us, every single one of us, including me, is when we get amped up or we get nervous, our speech tends to speed up and we breathe more shallow, and that begins to unsettle, and we start to speak even faster. So make a conscious effort to just slow down. All right,
Ready.
so I just gave you 3 minutes to kind of,
I took about 3 breaths. I think I'm fine now. I'm ready.
What did Thomas Jr. do for his dad's business?
He supervised approximately 10 employees, and then he occasionally performed additional duties, including purchasing equipment and vehicles.
Okay. So, what happened?
So he informed he was authorized by his father to attend the Nashville Auto Auction and was given full authority to purchase a
Do you see how much slower she's speaking? In just that, in just that 1 minute, you were able to just sort of turn off that panic part of your brain, and you just fell right into a rhythm. And so when you catch yourself, and you start, internally, chill. Just stop. Just chill, man. That's what I have to do sometimes. I've been doing this a long time. And it only took you like 1 minute to do that. Good for you.
Thank you. Thank you.
All right, so Thomas Jr. is a foreman in his dad's business, and the business needs a truck, right?
Mhm.
And so Dad says to Thomas Jr., go to this auto auction with my friend Smith and see if you can buy us a truck. He had another reason to go. What was that?
He informed his father that he would also look for a personal vehicle.
Okay. So he had 2 reasons to make this trip. One that was work related and one that was personal. It sets up the whole problem here. How does he get to the auto auction? They're in Red Boiling Springs. They have to travel some distance to Nashville to attend this auto auction. How does Thomas Jr. get from Red Boiling Springs to the auction?
So he travels with Lowell Smith, a used car dealer whose regular practice was to attend the auction and invite others to accompany him.
Okay. So he didn't take a company vehicle.
Mm-mm.
He rode with somebody else, some used car dealer that Dad knew. Does he find a truck for the business?
Mm-mm.
Does he find a vehicle that suited his personal needs?
Mm-mm.
And so what happens next?
So by midday of where he was at, he wished to return home to celebrate his birthday. So he wanted to leave early, and so Mr. Smith permitted him to drive a 1985 Buick Smith, or the Buick that Smith had purchased back to the used car lot.
Yep.
And then while returning, he used a route that was selected by Mr. Smith, Mr. Thomas did, and then he was involved in a head-on collision with a vehicle driven by Linda Roddy, seriously injuring Mrs. Roddy and her son.
That's right. That's the story. This case involves respondeat superior in the context of a traveling employee. Somebody who is away from the employer's premises and is negligent while traveling. And the question is, can an employer be held vicariously liable if the employee is off the premises traveling at the time of the tortious act? Now, before you tell us what the court here decided and why, in general terms, is an employer vicariously liable of a negligence of an employee while they are traveling?
Under the scope of their employment.
What do you mean?
With the prongs, if the employee was an employee on the employer's business and then acted within the scope of the employment at the time of the injury, then they would be held vicariously liable.
Okay, so as long as the employee is still within the scope of the employment while traveling,
Yes, yes.
respondeat superior still applies, right?
Mhm.
Okay, simple enough. If this accident had happened on the way to the auction instead of the way home, would there have been any question that the business, the dad's business, the lumber company would be held vicariously liable?
I don't think there'd be any question about that. I think he would be held liable or vicariously liable.
I think so too. That would be the easy case. The harder case is what happens when the employee, in this case Thomas Jr., leaves early because he didn't find a vehicle and he wants to get back home because it's his birthday and apparently he's going to have a party of some sort. So what does the court hold and why?
So the Mrs. Roddy and her son filed separate lawsuits against Mr. Thomas and Mr. Smith, and they sought total damages of $260,000. And then the trial court held that Mr. Thomas was acting within the scope of his employment at the time of the accident, and then ordered American Mutual to provide defense and coverage because all three of the individuals, Mr. Thomas, Mr. Smith, and Macon, were insured by different insurance companies. And then, so the court first addressed the standard of review about the trial court's determination that Mr.
Forget
Thomas.
about the standard of review.
Okay.
Let's jump right to the Court of Appeals opinion, which, by the way, did you notice who the author was on behalf of the court? Dean Cook. Keep that in mind for a minute. We're going to come back to that point. What did the Court of Appeals hold? And, or maybe, maybe a better way to ask that question is, does the court find that the employer is vicariously liable?
No, so they found that Mr. Thomas was not acting within the scope of his employment with Macon at the time of the accident.
Yep. Now, why? What's the
Um,
court's reasoning? What's the court's rationale? How did the court get to that conclusion?
so what I have is Macon had no control over Mr. Thomas's return trip. It could not reasonably have anticipated that he would borrow Mr. Smith's vehicle, drive it back to Smith's used car lot, or follow a route selected by Smith. And then I also have transporting a vehicle for Mr. Smith's used car lot was unrelated to Macon's logging business, and Macon's interests were merely incidental to Mr. Thomas's personal and third-party objectives.
He was, at the time of the Tortious Act, engaged in a frolic and detour. me ask you the hardest question of all. Did Judge Coke and his colleagues get this one right, in your opinion?
yeah.
Well, of course, yeah. You can't take the things on that one very long. Especially since that camera right there is always on. It records everything we do and say. More seriously, why? Why do you think this? If you were a judge having to decide this case, you would have decided it the same way?
Yeah, I think so, just because, I mean, we all know that he would have to get home somehow from there, but I don't think it would have been foreseeable the way he got it. Like, early and in another vehicle not driven by Mr. Smith or however, and then he also had his own objectives on getting home. It wasn't for the business or to get home because he had work the next day. It wasn't that.
So, okay. If any of you were on this appellate panel, would you have written a dissent? Anybody disagree with the court's conclusion here? I know we don't all agree with Judge Cook.
It can be argued that Dad sent his son to get the car while the son had the extraneous purpose of getting the car himself. Dad sent him there for the day. So for that day, he was an employee doing the employer's business, especially within the scope of the purpose.
You know, I think I would take that a step further even and argue, and it comes back to your point, which is the court's basis for the decision, that what happened here was not foreseeable. I would argue that it was entirely foreseeable from the employer's perspective. I mean, how was this employee supposed to get back to Red Boiling Springs if he didn't find a suitable vehicle? Sprout wings and fly? The employer knew he went with Smith, and the employer knew that he would get back via Smith, and he did, just a little early. But he was in a car owned by Smith, and Smith is the one that told him, okay, this is how you get back home. Why would that not be reasonably foreseeable under these circumstances? So at least in my mind, this is close. This one is really close. I totally get where the court's coming from. You know, you got to make a judgment call. But I think if I were on this appellate panel, I would have had to really, this one would have given me some pause. I'm not necessarily persuaded by the notion that what happened was just not reasonably foreseeable. What's your takeaway legally from this one?
Once you detour for personal or third-party reasons, the liability is on you, not the employees.
Say that again now?
I have, once you detour for personal or third-party reasons, the liability is on you, not the employer.
At the very end, you trailed off.
Oh, not the employer. So the liability is on you, not the employer for detouring.
Is that right?
I thought so. I might be wrong.
At one point in the opinion, the court says this: employers today are generally responsible for torts occurring within the zone of risk within which an employee might reasonably be expected to deviate, even for entirely personal reasons. How about that? even for entirely personal reasons. Well, if that is part of this legal analytical filter that the court set out at some length for traveling employee situations, if that's part of the analysis, I may well focus on the language in this majority opinion that concedes, even for entirely personal reasons, if an employee steps out the side of the scope and course of the employment, that doesn't necessarily vitiate respondeat superior. Do you have another takeaway from this one? How about something very simple? Very, very simple. Like, respondeat superior still applies in the traveling employee situation as long as they're acting in the course and scope.
Took the words right out of my mouth, yes.
Okay.
Perfect.
I
I love it.
Thank you, ma'am. You know, sometimes, I mean, lawyers and judges, and embryotic lawyers and judges, sometimes we just make things more complicated than what they really need to be. And I'll tell you, one of the hallmarks, one of many hallmarks, but one of them, one characteristic of a really good lawyer or a really good judge is somebody that can take something complex legally and present it in a way that is simple. That's not easy to do. The opposite of that is true as well. It takes no skill, no training to take a simple legal problem and make it complicated. Some lawyers are really good at that. Some judges are really good at that. But some of the best in our profession that I know just have this skill, which does take practice. It does take some effort to translate a difficult legal concept into language that clients can readily understand, that jurors can readily understand. And that's why I haven't said this in a while to you all, but way back, I think I've tried to encourage you, okay, after you get done with a case, pretend like you are speaking to your grandmother. And you have to explain to her what this concept means. And that's not as easy as what you might think. And you know what? That gets harder as you go on through your legal education. Because thinking in terms of these legal words, that just becomes second nature to you. That just becomes part of your language. Sometimes you hear the phrase, think like a lawyer. I hate that phrase. No, think like a normal person with the knowledge and skill of a lawyer. And you will be able to connect so much better with the lay people that you deal with on a daily basis. Your clients will love you for that. Okay, let's look at another one. Craig versus Gentry. Mr. Claiborne, tell us about this one. Why don't you come on up if you can?
How y'all doing today? Okay, bet. So this case involves a collision involving a automobile driven by Gentry and owned by her father, Calvin Gentry. It's a motorcycle, and the plaintiff is Alan Craig. Which plaintiff Alan Craig was a passenger. In this case, the complaint alleged that Ms. Gentry was on or about the business of her employer at the time of the accident. On that date, Ms. Gentry was employed by Williams. She and her coworker, included her supervisor, decided to purchase a popcorn popper as a birthday present for Mr. Williams, the daughter who was a summer employee. Ms. Gentry embarked on the mission to Target to purchase a gift and also go to the bank to make a company deposit. It was not uncommon for employees to use their own vehicles while running errands for the business. As she started the car, a man ran up to her and advised her that there were sparks coming from underneath the car. She decided to go to a close-by auto shack, and as she proceeded to turn into the auto shack, the plaintiff riding a motorcycle, they collided.
I may have missed it, but where was she going to go from Target? Where was her next destination?
She was on the way to the bank at that point.
Okay,
I just didn't say it.
all right. And why did she end up en route to Auto Shack?
A man, while she was at Target, told her that there were sparks coming from underneath her car.
Right.
So she wanted to get it checked just to make sure it was safe to drive, I guess. And then she also wanted to contact her father, who was also her employer at the time. Just let him know, like, hey, I'm going to Auto Shack. Or better yet, she could get a phone from a person that she knew at Auto Shack.
Okay, so she had friends that worked at this
Yeah.
this Auto Shack, and she knew that she could call her dad and see about this so-called mechanical issue. And this was before the days of cell phones. I know it's hard to imagine that for some of you, but if you wanted to make a phone call at the time this case arose, you had to actually go find a phone. It was not in your pocket. So here's the significance of that. Had she left Target with the popcorn popper and headed to the bank, she would have turned one way. But because she had this issue that she wanted to see about concerning her personal vehicle, she turned a different way. And that's when she hit the motorcycle. So the question in this case is the same as the question in the one we just talked about, which is whether at the time of the tortious act, or in this case, the time of the accident, whether she was acting within the course of her employment, or was she engaged in a frolic and detour. Keeping in mind, she turned away from the bank to see about a problem with her personal vehicle. What's the answer and why?
So the court said, with relation to a trip involving both the business of the employer and private purpose of the employer, there's a test involved. That test is if the work of the employee creates the necessity for the travel, he is in the course of his employment, thought he is serving at the same time some purpose of his own. And then it goes on to say that the work has to have a part in creating necessity for travel, and that the business errand had been dropped would have been canceled upon failure to private purpose. All that to say that when you embark on a private purpose, you're no longer in the course of employment matters. It's not within your typical duties of employment.
Okay, so in this case, was she within the scope of her employment when she hit the motorcycle or no?
She's not. But man, your face says otherwise. Did I read that wrong? In this case, the work of the employee Brown created the necessity for Brown to drive a motor vehicle from the hardware store. That's a different case.
Does respondeat superior apply here?
You know what? That's a great question. Who wants to help me out? Because I didn't read that part. What's up? What you got?
Basically, that they considered her going and checking the car out because she's going to the bank the same as going to the gas, so she's able to get to the business, and whatever job she has to do for the fall.
In order to get to the bank, she has to see about this problem with her car. The court concludes that she was acting within the course and scope of her employment.
I see that now. It's at the end. I didn't get that far.
Well, you had an hour to read it. What do you mean you didn't get that far? It's a short opinion.
I was paying attention to you.
Let me ask you this. Okay, now that we've established that she was within the scope of her employment, what if now she leaves Target, she instead of turning to see about a mechanical issue with her car, let's say she leaves the parking lot of Target, she turns toward the bank, and she realizes, well, I'm really low on gas. And so she just pulls into a gas station, fills her car up, and as she is leaving the gas station, she negligently hits somebody.
Just want to make sure I got the timeline right. You're saying that she's already gone to the bank and then.
No, she's on her way to the bank. She got the popcorn popper.
I would say it's within the scope of her employment based on this exact opinion and what we just talked about. She had to get there eventually. She had to get there some way. If she's out of gas, she can't get to the bank.
Okay. Just asking. Now let's say she's got her popcorn popper and she fills up her car. She's headed toward the bank. And her car starts to run like really rough. And she thinks she might have a flat tire, so she pulls into some tire store. And as she does that, she negligently runs into something.
Same set of facts.
Okay, so the employer is still liable, vicariously liable.
I believe so.
All right. They check out her tire. Say, your tire's fine, you're good to go. So now she's back off toward the bank. Car's full of gas, tire's good, got the popcorn popper, and it's lunchtime. So she pulls into some fast food place, drive-through, orders number 1. I think that's a Big Mac, isn't it? I thought it was. Glad I'm not the only one that knew that. And so she orders her number 1, you get it till she pays for it, and as she's pulling out of McDonald's parking lot, she negligently hits a jogger.
I would say that's inherently not a part of the employment process. Her exact duties in this case were to get a popcorn popper, go to the bank. She stopped for lunch. No one sent her to go get lunch.
No one told her to get her tire fixed.
Well, that was in the course of trying to complete her duties. Lunch is lunch. Lunch is a personal thing in and of itself.
Remember the language from prior case? that I read at the end. It said
In modern
employers today are generally liable for the torts committed by employees, even if they foreseeably deviate from the scope of the employment, even for entirely personal reasons.
And then that's the question of foreseeability. Was the employer, could they have foreseen her stopping for lunch? Was it
Well,
lunchtime?
What do you think the answer to that would be?
It's all based on the fact of this. For this one, I would say no, because it was most likely past lunchtime. It was
No, under my hypothetical, it is lunchtime.
under your hypothetical, then more likely than not, the employer would be held liable.
Okay. It ain't after lunchtime, it is lunchtime. Which for me is like right at 11 o'clock. I don't eat anything for breakfast at all, so come 11 o'clock, I'm hungry. And so when my staff and I, we go somewhere, they're like, it's brunch. Why do we have to go at 11 o'clock? It's not brunch, it's lunchtime. 11 to 12 is lunchtime. Am I wrong about that?
Yes.
Yeah. Don't do that too.
Very well. So, the employer is going to be liable when she leaves McDonald's?
Most likely, yes.
Okay, so she's on her way to the bank,
Mhm.
make the company's deposit, and she pulls out with somebody. Now her tank is full, her belly's full, tire's good, she's got the popcorn popper, she's on her way to the bank, and she passes the dry cleaners that she always uses. I mean, it's right there, so she just pulls in, picks up her laundry, doesn't even have to get out of the car. And as she's pulling on her way to get back out on the highway to head to the bank, she hits 5 joggers.
Oh.
She needs her license to work with both.
Is the employer still liable?
It's a question of foreseeability. Probably not. Most employers don't expect you to get your own personal dry cleaning while you're supposed to be going
Even
to.
for entirely personal reasons. The
But it's-
language just keeps
I agree, it does keep
bouncing
coming.
around in my head.
It's the foreseeability thing, though. So
Right.
if it's foreseeable, then I would wholeheartedly say yes, the employer is liable. But if it's not, then no. So that's the question of the jury.
If you're representing plaintiffs, what would your argument be?
I would definitely say that it was foreseeable. It was on the way to the bank. It was in the same route. She still hadn't dropped off the deposit. So everything up until that point was foreseeable. The employer should have known that, well, she might make some deviations, she might make some different departures, but it was all within the same mission of getting money to the bank.
Yeah, I think that's exactly the argument. So now her tank is full, tire's good, she's not hungry anymore, she's picked up her laundry, got the popcorn popper, and she's headed to the bank. She can see the bank now, but right before she gets to the bank, there's the post office, and she needs to get some stamps or mail some letters. Just right second, she pulls in there, and as she's pulling out, she hits.
She's going to jail. That's what's happening. She's going to jail.
I mean, she just runs over 10 Girl Scouts. There's a method to this madness, y'all. Follow along here.
Yes.
Is the employer still vicariously liable for that?
Most likely, barring foreseeability.
Okay. She's got her stamp. Not hungry, full tank of gas, tire's good to go. And her subdivision where she lives is right before the bank. And she's like, I think I'll just swing in, go down my street, pick up my mail out of my mailbox while I'm out. And while she's pulling out of her subdivision, she negligently causes an accident. Is the employer still liable for that?
Based on Farmers Mutual, yes, but they shouldn't be. That's not foreseeable for her to go home while you're supposed to be doing the work purpose.
I'm trying to figure out where you are going to draw the line.
My line was drawn a long time ago. I would have said after McDonald's, that's not foreseeable. But
Oh, okay, all right. But that's the issue, right?
it is. The issue is foreseeability, wholeheartedly. If it's foreseeable,
Whether it's the lunch thing, whether it's the tire thing, whether it's the gas thing, the post office, it's all, was that reasonably foreseeable? Tempered by that language that says an employer is generally liable when an employee deviates, even for entirely personal reasons. So I think I agree. There's no right or wrong to any of this. It is a matter of degree. But I agree with you. I think probably, well, I'm confident in saying that checking out the tire, yeah, that's going to be, in fact, the court says that in the case itself. Getting gas, same thing. Seeing about a mechanical issue, same thing. So I'm quite confident in saying she's not engaged in a frolicking detour there, unless certain, but still fairly confident, if she stops for lunch, doesn't take a 2 hour, go in some restaurant and hang out for 2 hours. She just, it's lunchtime, just swings through. I think a court would find that that's still within the scope of the employment. But once we get beyond that, it becomes much less certain. But whatever the height of that, you now know what the issue is, right? And you know what the legal analytical framework is in these traveling employee cases. When you put this one away, what's the takeaway for you?
foreseeability. That's the whole thing. Foreseeability. If it's foreseeable for an employer to, for an employee to cause an incident while on an employer mission, then it's the employer's fault, and they're vicariously liable. But if it's not, then
Let's say I'm a friend of yours, and I've never stepped foot in a law school classroom. And I know you're going to law school, and I tell you, I read this thing on I saw this article somewhere that used this weird phrase, respondeat superior. What does that mean?
do what your boss told you, nothing more.
I don't understand.
Well, that's unfortunate. No, but all seriously, it's
See my point?
in layman terms.
I mean, we're, you know, if we use legal words, it's not a problem. But if you can't use legal words, you have to like pause. Okay, how do I explain this to somebody a client that has no clue? So I'm a client with no clue. I'm an employee, I'm a business client of yours. And I come to you and say, you know, if I send my employees out to, you know, to do this or that, I can go to the bank, make other companies' deposits or whatever it might be. Am I liable for that if they hurt somebody?
If they were sent on this exact task that you were telling them to, and they didn't deviate in any manner, you're likely liable.
Exact task. Okay, good. So if they stop and get gas, I'm not liable. If it's lunchtime, I'm not liable.
Within reason.
What does that mean within reason?
If it's still in the mission of getting and doing what you asked them to do, then more likely than not, you will be liable. Getting gas, mechanical issues, the occasional lunch break at lunchtime. But for the most part, if it's for their own personal reasons, you could argue.
Okay. I can understand that. How might somebody else describe that to me as a business? A lawyer, I'm talking to my friend who's a bank president. He threw out this word, respondeat superior. And I just wanted to ask you about it.
So chief, if you're working with someone, if it is within the scope of something you would usually do, then the employer is responsible. So if the employer never lets you stray from your duties at work, then if you stray from your duties at work, it's not going to be acceptable. But if your employer is a little more lax and says, hey, you know, it's okay if you drive your personal car this time, it's okay if you stop the shop, then that is going to be under that scope of the employer's responsibility.
I think I understand that, the gist of it anyway. Somebody else. Yeah. Don't use any legal words.
If your employee, if you send your employee out to do something, they do something bad by accident, you're gonna be the one. There's a good chance you're gonna be.
Why am I going to be in trouble? Why am I going to be liable?
Because it's the law.
That is true. That isn't the answer that's going to satisfy them.
You as an employer are in charge of your employees, even if they go off your property to do work for you.
Okay. Yes, sir. Go ahead.
So I guess a slight question here, so.
Well, answer mine first.
Mr. Waters here deviates, smokes a blunt, is back in the truck, continues to drive. Well, you know, then, you know, it's still gonna be respondeat superior because he's, you know, engaged in, you know, still driving the company truck while he's on duty.
I don't. Yeah, all these lawyers know what you're saying, but I, as a layperson, have no idea.
So the employer is still responsible.
Why? Is my question.
Why? Because the employer is responsible for the actions of their employees.
Why?
And that would include, potential drug use by the employee.
Why?
Sorry, you said why?
Yeah. She says, oh, it's the law. Why is it the law? I'm trying to understand why my business would be liable.
I would say that, you know, government interest in keeping the road safe in that example. But again, I don't know if that's using legalese.
It's cold.
All of you do know the reason why. No.
It's your word.
Yeah, go ahead. Go ahead.
It wouldn't be making this threat if it wasn't for their employment.
Okay. Yes. And so while they are out making that trip or running that errand or whatever it might be, they are extensions of you. And so the negligence of the now put this back in legal terminology, the negligence of the agent is the negligence of the principal. Through the eyes, or maybe to not use any legal words, through the eyes of the law, your employees are just extensions of you, your business. So if they commit negligent acts, you're liable for that. That is at the heart of vicarious responsibility, legal responsibility. What was your question? You said you had a question.
Well, it's kind of like that example, if an employee deviates, is the deviation only while they are committing that deviation, or if the effects of such deviation continue, such as drug use while driving the truck? If they are under the influence, once they get back in the truck, continuing to drive below, down, or wherever, they're operating now as the employee, but still under effects of their deviation. So is the employer responsible in that scenario?
I think that's an easy case. An employee's intoxicated, maybe instead of stopping at pick up the laundry, he or she stops at a liquor store and just becomes impaired. Yeah, that's an easy no right there.
They're stopping at a liquor store, that's a deviation, so a tort that occurred while in a liquor store is, the employer is not responsible for a tort that occurs while they're on the road after being in a liquor store.
So, okay, so I think if I just translate your question, it's once an employee steps out of the scope of the employment, can they then step back in?
Yes.
And the answer is yes. Other cases have held that if an employee is engaged in a frolicking detour, once that's over, they can step back into the scope of the employment, which triggers respondeat ad superior again. Any final thoughts?
I have no final thoughts.
Huh?
I'm cold. That's about it.
Thank you, sir. Who had White versus Refco? That's where we're going to start next week. Okay, and then we'll do the Lisa M case, and then we'll just continue right on with this vicarious legal responsibility material. Thought I saw a hand. Yes, sir.
One of the deviation elements in your analogies earlier, only turning out Red River House, if the accident happens while you're driving to your house or check your mail, would that be a separation or a demarcation from the employment versus having to check the mail and no, in fact, to that?
Wouldn't it be great if we had a crystal ball to know how a court would decide both of those questions? We don't. But we do know what the issue would be that a court would have to decide. And because we can identify the issue, we know how to shape our argument depending on which side of the case we're on. So can I say definitively that a court would or would not impose liability? No. My gut tells me if we get that far where the employee is going home, that's going to be, I don't know, I would say the employer has the better argument there. Yep.
In all of your multiple examples, you kept waiting until she got to, until before she got to the bank, right? Which makes sense. But if she completes all her work tasks, she went to the bank, she did everything, and then she goes and does something personal before she goes back to the office. Is it this, I just want to make sure if once she's completed all work tasks, is that still within scope of employment, or could that then be considered?
Depends on whether it's reasonably foreseeable.
Got it, okay.
Right? Is she engaged in a frolic and detour at that point? That is what a court will have to decide.
Okay, so it doesn't really matter necessarily. I was trying to figure out if maybe once she's completed all of her employer-related activities, then
Yeah, she made the deposit. Now she's going back to the office, and on the way there, she stops and gets her laundry. Yeah, same issue. Same issue. Last one.
Could you give us a clear-cut example?
Probably not. A clear-cut example, what?
Of a frolic example where the employer would not be liable.
I like the drug use or alcohol use one. That's pretty clear. Before I get to the bank, I think I'm gonna, take these drugs. Or I'm gonna drink alcohol. I'm pretty sure a court would take a dim view of that. All right, y'all, we are out of time. Make sure I get the roll, and I'll see you next week.